Hello, everyone. This is Kevin again, bringing you the Worthy Law podcast for September this time. And this time I want to talk a little bit about some of the basic rules of civil procedure. The court system in Utah, I'm going to talk just about the Utah rules, which are very similar to the federal rules. But the state courts in Utah are governed generally by the rules of civil procedure. And if you have not been involved in a lawsuit before, or you haven't been involved in a number of lawsuits, maybe you've been involved in one, you might not be that familiar with the rules of procedure. There are a lot of rules, and they set out some pretty complicated standards. I don't want to try to get through all of them today by any means, but wanted to start with Rule 1. Rule 1 talks about the scope of the rules, and it says the rules govern the procedure in the courts of the state of Utah in all actions of a civil nature, whether cognizable at law or in equity, and in all statutory proceedings. And then it lists some exceptions. So I wanted to break that down a little bit, unpack that a little bit. So the rules govern procedure, how we do things, not necessarily the way evidence is presented, or the way that the substance of the matter is interpreted and ruled on in accordance with substantive law, but the procedure in the courts in all actions of a civil nature. So these are the rules of civil procedure, not criminal law. There's a big difference between civil law and criminal law. The substantive law is very different, and then also the way that the courts address the different kinds of cases is very different. So in a civil case, you're going to be dealing with the rules of civil procedure. And then the rule here, Rule 1, it talks about being cognizable at law or in equity. It talks about actions of a civil nature, whether they're cognizable at law or in equity. And that goes back to some distinctions that existed before these rules were enacted. It used to be that you either had to choose to sue at law or in equity. And I don't understand a great deal about those distinctions because those go back to the early 1900s at the latest, as I recall. And so that was long before my time. But these rules were given to supersede those old rules about law and equity. And so now we just have one set of civil rules that are for all actions of a civil nature, as opposed to actions of a criminal nature. So you've got the civil rules here, and then there's an interesting statement here. And I've used this. I don't often refer to Rule 1 in any of the different things that I file with the court, but sometimes I will refer to this section of Rule 1. It says that these rules shall be liberally construed and applied to achieve the just, speedy, and inexpensive determination of every action. And I want to take a step back, not talking about any specific case or situation, but just talking about getting a just, speedy, and inexpensive determination of your action. And to my mind, there's a fair bit of irony in this section of Rule 1 because I think one of the problems that you often run into in the legal system is that the result is not necessarily just. And I think another problem that you run into, especially if you're not familiar with the system, and especially when you get used to the rapid speed at which so many things happen these days, you might not find the resolution of your dispute to be all that speedy if it goes all the way through the court system. And you really should expect, even in a small case, you should expect to wait at least 18 to 24 months before you actually get to trial. That's not going to happen in every case. There'll be some exceptions, but for the most part, even in a small case, it's going to take 18 to 24 months to get to trial. And in a bigger case, it's going to take longer because you're going to want to do more in terms of investigation, and the parties are probably going to argue more, and it's just going to delay things and cause there to be more time between the time that you file a complaint and then actually end up in court in a trial. And then also, this idea of an inexpensive determination of the action, I think that given the complexity of the rules and the complexity of procedure, most people are not going to find the litigation process to be particularly inexpensive. In fact, I think most people find it to be a lot more expensive than they had anticipated if they've never been involved in any kind of action before. So for me, like I said, there's a fair bit of irony there, and I think it's unfortunate because I believe that somehow the system should be able to give us just, speedy, and inexpensive determinations of disputes. I don't know a lot about the German system. I know that Germany has some really terrible history, and putting that aside, I've heard that the German legal system operates in a way that is a lot less expensive, and a lot of that has to do with discovery. I don't want to get into a comprehensive discussion of discovery because discovery is a really big topic. But one of the distinctions that I've learned a little bit about between the German courts, for instance, and the United States courts is that the discovery process in Germany is much more abbreviated. In fact, it's a lot like the discovery process that we used to have in the United States. You used to have virtually no discovery in the United States. You had to have the evidence in support of your case before you filed your complaint. Now, that's still a good idea to have as much evidence in support of your case as you can get before you file your complaint, but it's not required in the same way. You still have Rule 11, which requires you to have some factual and legal basis for the things that you're asserting, but you also have discovery, and discovery gives you an opportunity to seek documents either from other parties in the case or from third parties by subpoena. You can also interview witnesses under oath at depositions, again, either by notice to an opposing party or by subpoena to a third party. And that process can be very involved. You can get a lot of documents and you can interview or examine, we might say, a lot of witnesses. And so that takes time. And a lot of times what ends up happening is the case gets tried in that discovery period effectively, because the case doesn't actually go to trial. Either it gets decided on a motion, like a motion for summary judgment, or maybe a motion to dismiss, though the motion to dismiss is usually going to be independent of discovery because it generally doesn't require you to say anything about the evidence in the case, and discovery is all about evidence in the case. But be that as it may, I think all this goes back to this idea of the inexpensive determination of the action. And we just have a very complicated system. And so I think it behooves everybody to realize that once you file a complaint, and we may talk about that. I'm about out of time for this month's podcast. I try to keep these short. But maybe next month I'll talk about the commencement of an action and maybe a little bit about the rules for what goes into a complaint. And once you make that decision to file a complaint, you've really embarked on something that's going to be probably a pretty big part of your life. There's going to be significant time, there's going to be significant expense, could be significant anxiety. So those are all things to think about when you're thinking about filing a complaint. Also, of course, things to think about when you're faced with a complaint, if you've been hit with a summons and a complaint and you need to respond to that. So there's a little bit about Rule 1 and the scope of the rules of civil procedure and how the courts work these days. If you've made it this far, then thanks again for listening, and God bless.